Good afternoon. My name is Judge Kathleen McCarthy. I'm your judge this afternoon. You are here for first appearance court. Today is the day that I will inform you of your charges, determine whether there is probable cause for those charges, and then determine whether you can be released from custody. Since today is not your trial day, you do not need to comment on your arrest or the facts surrounding your arrest. You have the right to remain silent. You should use that right at all times. However, if you give up your right to remain silent, whatever you say about your arrest or the facts surrounding your arrest will be used against you. This hearing is being recorded. If you have a private attorney, please let me know that when you are called forward. All right, Mr. Lind, we have a Portuguese interpreter.
We do have a Portuguese interpreter, Your Honor.
Do you need some time to?
No. You might want to ask Mr. Romero over at the main jail if he needs any time to talk to this to Mr.
Mr. Romero, how are you?
Good afternoon, Judge.
Okay, we have a Portuguese interpreter. Do you need a moment to speak with her?
No, I'm ready to proceed, Judge.
Okay. All right. Madam Clerk, will you swear in the interpreter? Okay. Mr. Romero, do you have Mr. Jose Martins Neto with you?
Correct, he's right next to me, Judge.
Senhor Romero, o senhor tem o senhor José Martins Neto, consigo sim, meritíssimo está aqui ao meu lado.
Sir, you're being charged with touch or strike, battery, Dayton violence, and number 2, abuse, child abuse without great bodily harm.
Senhor, o senhor foi acusado, então, fato número 1, de tocar ou atacar, agressão, violência no namoro, e fato 2, abusar criança sem grande lesão corporal.
State,
Estado.
does the defendant have a criminal record?
I see no history, Judge.
All right, Mr. Romero, what is the bond or pretrial release recommendation?
Judge, that's what I was going to recommend, if the court would consider releasing Mr. Martinez
he's got
release.
Hector, the interpreter has to interpret with the
Yes,
judge.
I'm sorry.
Okay, Mr. Romero, do you mind going slower so the interpreter can interpret?
Sorry, I didn't have a chance to
That's
start.
okay.
Ok, o Estado tem alguma coisa a dizer. Ele não tem nenhum antecedente. Sorry, please.
Judge, as you heard, he has no prior criminal record.
Senhora juíza, como a senhora ouviu, ele não tem antecedentes criminais.
I was going to ask the court to consider releasing Mr. Martinez on standard pretrial release.
Eu gostaria de solicitar à corte que liberasse o senhor Martínez na soltura padrão.
The problem is, unfortunately, when he was arrested, he left his phone at the house, and he has no numbers memorized, so he has no one to contact to help post his monetary bond.
Okay.
Infelizmente, né, o telefone ficou na casa e agora ele não tem os telefones, não sabe os telefones de memória, então ele não tem alguém para entrar em contato com relação à fiança.
The state is going to oppose outright ROR based under these allegations.
Meritíssimo, o Estado vai se opor ao ROR com base nas alegações.
I'm
Okay.
concerned that after striking the alleged victim, she retreated to her room and locked the door.
Minha preocupação é que depois dele agredir a vítima, ela foi para o quarto e trancou a porta.
That he would go to the lengths of throwing the victim's 15-year-old son down onto the ground to get access to the room where she had locked herself in.
E ele chegou ao ponto de atirar o filho da vítima de 15 anos no chão para poder ter acesso ao quarto.
And then went to the lengths of actually trying to kick the door in.
E daí chegou ao ponto de tentar chutar a porta para arrombá-la.
You're requesting a $2,500 bond on each count and no victim contact.
Então, vou solicitar R$ 2.500 para cada um dos fatos e que não tenha nenhum contato com a vítima.
Judge, if I may modify my request.
Okay, let's hear.
Senhora Meritíssima, se eu pudesse, então, modificar o meu pedido.
I spoke with Mr. Martinez earlier this morning.
Eu falei hoje cedo com o senhor Martínez.
He did advise me during the break he was able to recall the phone number of his boss.
Ok? Ele me avisou durante o intervalo que ele conseguiu lembrar-se do telefone do chefe dele.
Now, he works as a carpenter, and he's been working for him for the past year.
E ele trabalha como carpinteiro e está trabalhando para ele já por um ano.
If the court's not inclined to release Mr. Martinez on straight pretrial release, I'd ask the court to consider setting a $1,000 bond on each count.
Ok? Então, se a corte não estiver inclinada a liberá-lo antes do pré-julgamento, então eu gostaria de solicitar que fosse $1.000 por cada um dos fatos.
Okay. The court's going to go ahead and find probable cause in this case. We're going to set bond with regard to charge number 1 at $2,500. With charge number 2, we'll set it at $1,000. Sir, you're to have no contact with the victim, either direct or indirect. Do you understand that?
Ok? Então, a corte julga haver causa provável, então a fiança vai ser de $2.500 para a acusação de número 1 e da de número 2 vai ser $1.000. E o senhor não poderá ter nenhum contato com a vítima, quer seja direta ou indiretamente. O senhor entende isso?
And that would include both the mother and the son.
Isso inclui ambos, a mãe e o filho.
Okay.
And Judge, I'm going to be requesting a photo order.
Granted.
Excuse me, photo order.
Photograph order.
E meritíssimo, vou estar solicitando, então, uma ordem da fotografia.
Melinda Bolton?
Ms. Bolton is approaching, Judge. She's here at Main. Come on up, ma'am.
All right, Ms. Bolton? You've been charged with touch or strike battery. State, does the defendant have a criminal record?
As far as Broward, Judge, 2014 felony theft, possession of cocaine, 2013 theft, 2013 theft.
All right. Mr. Romero?
Ms. Bolton did advise me of those priors, nothing similar in nature as far as what we have before you. Now, unfortunately, right now, from what she advised me, she has no one to contact to help post her monetary bond. At this time, she's 31 years old, been residing in our community for the past 6 years. She just got a job about 11 months ago working at the Mandarin Village in customer service located in Plantation, where she's making about $9 an hour. She is living in Plantation. The alleged victim is a roommate. I did advise her that the court's going to order no contact. She will be abiding by that no contact order. She'll be finding a separate place to live. What I'm going to be asking one request is if she can go back one time with law enforcement to retrieve her property. And second, Judge, I'm going to be asking the court to consider releasing Ms. Bolton R.W. on pretrial release on this misdemeanor offense.
All right, ma'am, the court's going to find probable cause. We'll release you on standard pretrial release. We'll also allow you to go back to the residence with law enforcement to pick up your belongings. And you're to have no contact with the victim, either direct or indirect, pending further court order. Do you understand?
Yeah, yes, ma'am.
Yep. Tomorrow at 8 in the morning, okay?
Okay.
Sharada Renate Hobbs?
North Broward. Good morning.
Hi, ma'am. Are you Miss
Hi.
Hobbs?
Yes, ma'am.
Okay. Ma'am, you've been charged with grand theft. State, does defendant have a criminal record?
Yes, one moment, Judge. Your Honor, I'm showing from this year, possession of THC, she, I pled that out, a couple months ago.
Defense, what's your recommendation with regard to bond or pretrial release?
Your Honor, based on my conversation with Ms. Hobbs, I am going to be asking the court to place her on pretrial release. She is unfortunately not in a position to post a monetary bond. She has lived here in Florida for the last year. She does not work because she has a medical condition, so she collects SSI. Unfortunately, that is not enough to really accumulate any type of savings in the bank or anything like that, so she doesn't have the ability to post a monetary bond. So I would be asking the court to consider placing her on pretrial release.
All right, the court's going to find probable cause. She'll be released on standard pretrial release, but I want her to phone in once a week.
Your Honor, I'd also be asking for a release condition that she's not to return until further order to the court to the Seminole Coconut Creek Casino.
Okay, ma'am, pending further court order, you're not to return to the Coconut Creek Casino. Do you understand?
Yes, ma'am.
Okay.
Yes, ma'am.
All right. Once a week? Yeah, thank you.
All right, thank you, Judge. Good luck, Ms. Hobbs.
Thank you.
Stephen J. Belger?
Mr. Belger is here at main judge approaching. Mr. Belger, come on up, please.
All right, sir, you've been charged with driving while license suspended, first offense, and capious misdemeanor. State?
Your Honor, I have nothing to add.
Judge, my understanding, I spoke with Mr. Belger. I see count two as a 2016 offense. He advised me he simply missed court because he had health issues. He suffered 3 strokes. Since that date, he was more concerned with his health. Having said that, Judge, we're going to be asking for the court to consider releasing him on pretrial release. My understanding right now is he's on a fixed income. He gets Social Security. He's 72 years old. He lives in Sunrise. He's been living at the same place for about 15 years now. So we're asking the court to consider releasing him under supervision of pretrial.
State would oppose, Your Honor. It's been 3 years, and I'm sure that there was opportunity within the past 3 years for him to turn himself in if he was aware he missed a court date. The only reason he's before the court in the capious is because he allegedly committed the same offense that was pending to begin with. He was driving unlawfully.
Mr. Romero, when did he suffer his last stroke?
2 years ago. Judge, I've been informed about 2 years ago. The only other mitigating circumstances is this, Judge. On count 2, on the driving while license suspended, basically, I believe the date he was given a notice to appear was August 12, 2016. At that time, my understanding, speaking to him, he did have a valid license. He simply just forgot it. It was at home. When I looked in Odyssey and I pulled up the ticket, it even says under officer comments that he left his license at home. That's what Mr. Belger informed the officers. So at the time, he did have a valid license, but he didn't have it with him. That's what he's informing me. I can't say that as to count 1 was here before you today, Judge, but he did advise me. He now understands that, the importance of coming to court. Unfortunately, because of his financial circumstance, he can't afford bond. He has health issues, so I'm asking him to be now released under supervision. He will have a pretrial release officer that will tell him when his court date is to make sure he doesn't miss court. He did apply with the public defender's office, so he can contact his attorneys to find out when his future court dates are. So I'm asking him to be released in a pretrial.
It's a filed charge. I know he's claiming whether he had his license or not, the state investigated before filing the information, made a determination that his driving privileges were suspended at the time of that stop.
Okay, the court's going to find probable cause. He'll be released on standard pretrial release.
Here's pretrial. You need to report there. You'll be released today. You have to report there tomorrow, 8 in the morning. If you don't show up, there's going to be a warrant issued for your arrest. Do you understand?
Yes, of course. Where is it?
Follow the map. Here's the main jail. Follow the
Your
map.
mic is on, Hector.
Oh, sorry.
Mario Solomon Talavera Ruiz.
Judge, he's approaching. He's going to require a Spanish interpreter.
All right.
We have one on the way.
Okay, so this
Toma
will
asiento,
be
señor. Estamos
a
esperando
brief
un
reset. Andrew Angel Leon.
He's here present, Judge, at Maine. He declined the service of public defender. He will be hiring his own private counsel. Mr. Leon? Mr. Leon?
Mr. Leon's bond's been posted?
If he's there.
Mr. Leon, come on up.
Sir,
Yes.
you've been charged with DUI, alcohol, or drugs first offense, and DUI with damage to property or person of another.
Yes, ma'am.
The court finds probable cause. I was just informed that bond has been posted for you, sir.
Good morning, Your Honor. Nancy Mappson, pretrial services. Currently, I'm a pretrial for case number 1900022 CF10A for aggravated fleeing and eluding, resist, obstruct without violence, and failure to register a vehicle. I'm requesting that this pretrial is revoked on all three cases, Your Honor.
All right. Sir, you declined the
Yes.
services of the public defender, correct?
Well, yeah, I haven't hired my lawyer yet, but yeah,
Are you sure you don't want the services of the public defender?
I would like it until I get my lawyer, yes. But,
Judge, in that case, he's indicated right now on the record that he wants to help with the public defender's office. So, Judge, what was the request being made?
That the defendant's pretrial status be revoked?
Judge, that's what we talked about. My understanding is, as you're aware, he is out on, I believe, case number 19322 CF10A. In that case, he does have private counsel retained, and that private attorney is Mr. Adam Harmon. When I looked on Odyssey, I see that he has a future court date of December 20th of this month. I don't know if your honor is inclined to take action on that case, if somehow maybe his private counsel can be contacted in reference to that case, maybe he might have some insight as to a good reason why not to revoke his pretrial release and hold him no bond, especially when he has a court date coming up
I just had a kid 2 days ago.
and he's been going to court.
Okay, so you're asking the court to defer pending notification of his attorney?
Yes, Judge. I believe if the court's inclined to take any action, he has private counsel retained. His private counsel should be afforded the opportunity to speak and advise the court any reasons why not to take action on that case.
Your Honor, there's no law or case law or statute to support that. When pretrial prepares a warrant and goes to the assigned judge, does the assigned judge say, wait, I need to get his attorney here before I can sign that? No.
Okay, all right, I'm gonna go ahead and grant that request, that it be revoked. It can be brought up before the, which judge is that before?
Call roll.
Okay,
Spanish interpreter is present, Your Honor.
okay. Hello, how are you? You wanna come on up? Madam Clerk, would you please swear in the interpreter?
I do. Esteban Velasquez.
Oh, senor. Yes.
Mr. Ruiz?
Señor Ruiz,
Sir, you're being charged with DUI, alcohol, or drugs, first offense.
señor Ruiz, a usted se le acusa de conducir bajo la influencia de alcohol o drogas. ¿Es la primera infracción?
DUI accompanied by a person 18 years of age or younger.
DUI, al estar acompañado por una persona de 18 años o menor.
3, driving while license suspended, first offense.
3 cargos de conducir con la licencia suspendida en grado de primera infracción.
And failure to use due care.
Y no ejercer el debido cuidado.
State, does the defendant have a criminal record?
¿Fiscalía tiene antecedentes el señor?
I did not see anything, Judge.
No vi nada, señora juez.
All right, Mr. Romero.
Judge, based on the fact that Mr. Talavera Ruiz has no prior contact with the criminal justice system, And I'm gonna be asking the court to consider releasing him ROR or in the alternative on pretrial release.
Señora juez, dado el hecho de que el señor Rivera Ruiz no ha tenido contacto con el sistema penal anteriormente, voy a solicitar que lo excarcele bajo palabra o bien, en su defecto, que lo libere con medidas cautelares.
Your Honor, I have no objection to pretrial.
Su señoría, yo no tengo ninguna objeción a que sea con medidas cautelares.
I would request, though, that there be release conditions of no alcohol or intoxicants,
Sin embargo, sí solicitaría que se les impusiera como condición el no consumir alcohol o intoxicantes
and random drug and alcohol testing,
y que sea sometido a pruebas de alcohol y drogas sin aviso,
considering the alleged breath results.
dado el resultado que supuestamente dio la alcoholemia.
All right, sir, the court's going to find probable cause. You'll be released on standard pretrial release. I'll adopt the state's recommendations, no alcohol or intoxicants until
Bien.
further court order.
Bien, señor, voy a adoptar la recomendación de la Fiscalía, voy a liberarlo bajo medidas cautelares. Debe acatar la condición ya enunciada, en el sentido de que no debe consumir alcohol ni intoxicantes, será sometido a pruebas de drogas sin aviso.
Random testing, Your Honor.
And random drug testing.
Y pruebas de alcohol y drogas sin aviso. Is that all for the Spanish, Your Honor?
I think so. Mr. Romero?
Thank you. As far as Maine goes, that's the only person that requires Spanish interpreter, Judge.
Okay,
I don't know the other facilities.
let me find out. Paul Rain, do we need a Spanish interpreter?
No, Your Honor.
Thank you. Conti, do we need a Spanish interpreter?
No, ma'am.
Thank you, sir. North Broward, do we need a Spanish interpreter?
No, ma'am.
All right, thank you. All right, thank you for coming over.
See you later.
Kevin Williams?
Conti, Your Honor.
All right, Mr. Williams. Are these add-ons?
They are, Your Honor.
Okay, sir. You're being charged with petty theft, second degree, third subsequent offense, grand theft, petty theft, second degree, third subsequent offense, grand theft, and another grand theft. State?
Your Honor, Mr. Williams is county sentenced on charges 1 and 2 with an expected release date of May 5th of 2020. Based on that, I'm just asking that the standard bonds be kept in place.
He's currently enrolled in the life skills program, and from what he advised me, if he successfully completes that program, then his sentence could be mitigated. But I agree with Mr. Lender as far as Mr. Williams' current bonds on these counts. There really isn't much I can do to help him out, because he's not getting out no matter what I do or what the court does here today, so.
All right, the court's going to go ahead and find probable cause and keep the standard bonds in place. By the way, for charge 4, that's $750. For charge 5, it's $1,000. Charge 6, $750. Charge 7, $1,000, and charge 8, $1,000. All right, thank you.
Good luck, Mr. Williams.
Clifford Anel Cadavel.
He's here present, Judge of Maine.
Okay, sir, you've been charged with burglary with assault or battery. State, does the defendant have a criminal record?
He does, Your Honor. And this is a punishable by life offense. However, I'm not going to be seeking a no bond hold. I am going to be seeking a $25,000 bond, pretrial release of the GPS monitor, no victim contact. I do believe he poses a significant danger to this victim based on these allegations, his criminal history, which I will now provide to the court. Your Honor, he was arrested in, well, first I would like to bring to the court's attention the victim in this case is his mother. He was arrested for battery and resisting without violence in 2017 against the same alleged victim. The charges were dropped. According to the allegations, he punched the victim in her face when she wouldn't come back in the house before police arrived. They had been called due to an altercation. The victim had visible swelling and bruising around her face and left eye. 2017, he was arrested for violating the no contact order from the previous 2017 battery I had told you, I just advised you about, and that was dropped. In 2016, he was arrested for shooting at or throwing a deadly missile and criminal mischief. That was against a different alleged victim. The allegation being, those charges were dropped, the allegations being that he threw a liquor bottle at the victim while she sat in the driver's seat of her vehicle. He then produced a gun and fired several shots into the air. 2 bullet casings were recovered on scene. In 2014, he was arrested for an aggravated battery against a pregnant victim. That was dropped. In that case, different alleged victim. They were involved in a 3-year relationship. He allegedly struck the victim several times in the face and her arms with a closed fist, causing laceration and swelling, and this was done when the victim was 8 months pregnant. He had a disorderly conduct in 2014. Nothing further, Judge.
And Judge, in speaking with Mr. Cannavale, he's not going to be able to afford what the state is recommending as far as $25,000 bond. My understanding is he works when he can at a labor pool. You get paid daily, anywhere from $60 to $85 a day. Now, he's been here his whole entire life. Right now, he currently has other matters, in which he has a $5,600 total bond. He can't even afford to post that. From what he advises me, he has no one to contact to help post his monetary bond. He owns no sort of property, has no sort of money in the bank. I'm asking you to take that into consideration in determining reasonable release conditions for Mr. Cannavale.
All right, the court's going to find probable cause. Bond's going to be set at $25,000 upon release. He will be on pretrial release with the GPS monitor and to have no contact with the victim pending further court order. Brandon Marshall?
Mr. Marshall, come on up.
All right, Mr. Marshall, you're being charged with petty theft, 2nd degree, 3rd subsequent offense, resisting officer, obstruction without violence. You also have a warrant and a violation of pretrial on case numbers 19008480 CFA 10A, 19010822 CF 10A, 19011237 CF 10A, and lastly, 19012190 CF 10A. State?
Your Honor, in light of the no bond holds for the violation of pretrial, I'm just requesting that the bond on charge 1 remain in place.
Judge, considering the no bond holds, nothing to have from the defense.
Okay, the court's gonna find probable cause. We will place bond for charge number 1 at $750. Do we have a date for the,
I don't know, but, yeah, I don't know if it's automatically placed on the judge's docket or not, or if it'll be up for the defense to file a motion.
okay,
It appears he is set for court on the other cases for December 20th at 8:30.
okay. December 20th at 8:30, sir. You have a hearing on your other cases. Thanks, Mr. Reedy. Giovanni Lamont Linder?
Mr. Linder, come on up. He's approaching, Judge.
All right, sir, you're being charged with possession and intent to sell, manufacture, deliver heroin within 1,000 feet of a specified area. Number 2, sell cocaine within 1,000 feet of a school or childcare or park. Number 3, attach registration license plate not assigned, operating without a valid driver's license. And lastly, driving wrong way down a one-way street. State?
Your Honor, as you can see, Mr. Linder is 18 years old. Last year, as a juvenile, he was adjudicated delinquent for possession of amphetamines, and in a separate case, trafficking controlled substance and possession of controlled substance with intent to sell or deliver.
Mr. Romero?
If I may, Judge, I don't believe that there's sufficient probable cause to support the delivery of heroin charge. It appears as though he, according to the report, was in possession of 3.8 grams of heroin. And just because there's no drug paraphernalia or other items that would be consistent with the use of narcotics. I don't know that just based on the weight alone, that there could be a probable cause established that this was in possession with intent to sell. I guess he had a number of crack cocaine rocks, according to the report. But I would argue on that count that we don't know what it is, unless I missed it, which is entirely possible, what he was in 1,000 feet of. Was it a school? Was it a building? A store? A park? How was it measured? I just don't see any of the information regarding the distance between Mr. Linder's arrest and the area that's designated that he's supposed to be within 1,000 feet of.
Well, Your Honor, I'm fine with no PC on the enhancement, that being within 1,000 feet of a school. It does mention a school, but there's no other additional evidence. I do think there is ample evidence for the court to find that there was probable cause, that this goes beyond just mere possession and possession with intent. I think it's based on the totality of the circumstances, that he was in possession of 3.8 grams of heroin, in addition to 9.5 grams of crack cocaine, with a total of 61 crack rocks, that he also was in possession of almost $2,000 cash that was, and as the officer puts it, resembled a dealer's wad. This all took place in an area known for narcotics use, sale, and distribution. This evidence goes well beyond mere possession, Your Honor. Also listing the packaging.
Okay,
Also lists
the
packaging.
court's in agreement with regard to the enhancement. There's no PC, there's no specification of any
If I may just have
distance.
one final word, Judge?
Yes,
As to the possession of heroin with intent to sell, the fact that there's money in the car, I understand that can possibly be an influence. It could have been from the sale of cocaine and not have anything to do with the heroin. So I don't think that there is probable cause to establish that Mr. Linder was in possession with intent to sell heroin. I would ask the court to give very little weight to the idea that this is a neighborhood known for narcotics, because anyone in that neighborhood is entitled to the same protection under the law as people who are not in that neighborhood, and that would include Mr. Linder. So that would be my last word on the subject.
Mr. Reedy, certainly the defense can raise that defense at trial, but to argue that there's no PC because he's speculating that the cash could only be connected to one drug and not the other, it's the totality of these circumstances that gives the officer probable cause.
okay, so the court's gonna find probable cause. With regard to charge number 1, bond's gonna be set at $5,000, charge number 2, $5,000, number 3, $25, and 4, $25.
Thank you, Judge.
Corey Alexander McCullough?
Come on up, sir.
All right, Mr. McCullough, you've been charged with operating without a valid driver's license and probation violation or community control. You have a VOP hearing on December 3rd at 8:30 a.m. Anything from the state?
No, Judge.
Mr. Romero?
Nothing from the defense, Judge.
Okay, the court's gonna find probable cause. Bond's gonna be set for $25 for operating without a valid driver's license. And of course, sir, don't forget you have a hearing December 3rd at 8:30 a.m. Okay, I think we're finished with that portion of the docket. Did I miss anyone?
The only thing I saw, Your Honor, I wasn't here this morning, we got a reset page was added, and there was one gentleman on it that we didn't call, Dane Josephs.
I had the paperwork, let's see. I had the paperwork for Jose Martinez Neto. I didn't see, right, I didn't see any other paperwork for,
You can only deal with what you have in front of you, Judge.
okay. I just have the reset,
Oh, yeah,
just
yeah.
one page.
I was just, if you don't have the paperwork, then you don't have the paperwork.
Okay. Do you want me to recall this?
No, I mean, if we don't have the paperwork, there's nothing really we can do. Yeah.
Okay.
He refused, Judge.
Oh, he refused?
Yes,
Okay,
ma'am.
He's gonna, and just so you know, Judge, he's gonna end up going to mental health court. He was referred.
okay, all right, thanks. Okay, Carlene Cadet.
Hold on, y'all. Good morning. Good afternoon.
Hi, Miss Cadet.
Your
Where
Honor,
did,
this is a motion for release.
all
The
right,
state filed an information on November 22nd. It was filed as presented, the charge.
all right. We're here for the defense's motion?
Yes, defense motion for release, Judge. And Your Honor, that's why the defense motion was to see if the state filed an information or not.
Okay.
And the state has.
All right, and that's it?
I think that's it.
All right.
I'm just checking to see if if the clerk scheduled an arraignment yet. It's probably the arraignment. Sorry, I'm looking up right now. Yes, Ms. Cadet is scheduled for arraignment before Judge Merrigan tomorrow morning at 8:45.
Okay, ma'am, you're gonna be in front of Judge Merrigan tomorrow morning at 8:45.
Okay.
All right.
All right.
Dana Myers?
No problem.
All right. Mr. Rady?
And Your Honor, I can tell you the state did not file an information as of yet on this matter. Ms. Myers is entitled to an ROR on these charges at this time.
Okay, granted.
Thank you.
All right. You're
Luck,
welcome.
Miss Myers.
Mark Alberti?
Conti, Your Honor.
All right. All right, Mr. Alberti?
Yes, ma'am.
Your Honor, the state did file an information, the charges were filed as presented, November 27th. An arraignment date has not been scheduled yet, but I imagine the clerk will be scheduling one relatively soon.
All right. Mr. Reedy?
There's nothing to add, Judge, at this point in time. I think the subject matter of this motion deals strictly with the time frame that the state has to file the charge.
Okay. All right, good luck, sir. Sylvester Bryant?
Case here, Judge, approaching here at me. Come on up, sir.
All right.
Your Honor, information was filed earlier today. It's reflected by Odyssey. The state filed the first two counts of uttering a forged instrument, and the last two counts of petty theft were declined and merged into the first two counts. An arraignment date has not been scheduled yet, but again, I imagine the clerk's office will be scheduling that soon.
Alex Coleman?
Paul Ryan, Your Honor.
Pardon me?
Paul Ryan.
Just be deleted.
Are you Mr.
How you doing?
Coleman?
It could be deleted.
How you
Yes,
doing?
ma'am. How you doing?
Okay, I heard you were in front of your division judge this morning, ROR?
Yes, sir. Yes, I was. I was gonna let you know that.
Okay, thank you. All right,
All right. Appreciate you.
no problem. John Hercules?
Conti, Your Honor.
All right, Mr. Hercules, state?
If you're not clapping your hands. Actually, Your Honor, The next two cases belong to Mr. Hercules, and the state has not filed an information in either case, so he's entitled to release on both cases.
All right, sir, the court's going to ROR you on both cases.
Okay, thank you.
You're welcome.
That's for the 4 counts, right?
Pardon me?
It was 4 counts of the same thing, right?
Yes.
Yeah, for the 4 counts.
Okay, thank you.
All right. Tasha Walker? She's in North, Mr. Reedy?
I believe so, yes.
Yes, she is.
Okay. Miss Walker?
Hi, Your Honor.
Hello.
Walker?
Yeah. Tasha Walker?
Yes? Not so subtle. Your Honor, the state did not file information in this matter. She is
ROR?
entitled to an ROR.
Okay, the court's going to ROR.
And
Deputy?
for the record, so it's clear, we do waive her presence.
Deputy, the public defender's waiving her presence.
Okay,
Okay?
okay, thank you.
Ronald Shepard?
Conti, Your Honor.
And the state has not filed an information on this matter, Your Honor. Mr. Shepard is entitled to an ROR on this charge.
All right, sir. Did you hear that?
Yes, ma'am.
Okay. ROR.
Thank you.
You're welcome. Jade Noel?
Posted bond.
All right. Bond was posted on that. Adesh Prasad?
North Broward.
Good afternoon, Your Honor. How you doing today?
I'm doing well, thank you. All right, State?
Your Honor, this is a second look hearing and for a bond review. He was arrested last week for battery on a law enforcement officer and loitering and prowling. Bond was set at $1,500 on count 1, $500 on count 2. I believe it was set by Judge Canner. Your Honor, I do believe these bonds are appropriate and necessary. First off, the allegations in this case is that Mr. Prasad was loitering and prowling in a garage area looking into a motorcycle side storage when law enforcement, he was brought to law enforcement's attention.
Your Honor, may I speak, please?
Don't say anything about the facts of your case, Mr. Prasad.
I wouldn't say anything about the facts of the case. Your Honor, I didn't
Hold on one second.
Hold on 1 minute, sir.
He's then alleged to have spit on one of the arresting officers. Advising the court of his recent history. This year he was convicted of burglary of a conveyance, sentenced to 180 days county jail. He was convicted of criminal use of personal identification information, 180 days county jail. Loitering and prowling, and I think the court should be aware, in one of those cases, he was accused of going into someone's mailbox and stealing their property from their mailbox. In another case, while doing lawn work, he's accused of going into someone's home and stealing property from the individual's home. He had a battery. I would note the two felonies in 2019, the burglary conveyance and criminal use of personal identification information. He was out on pretrial on both of those cases. He had his pretrial violated because he committed a new law offense while he was out.
Okay, so we're just here for the bond, is that correct?
Yeah, it's just a bond, but it's just, I'm just advising the
Okay.
court, you know, he has a history of when he's out, either on pretrial or on bond, he commits new law offenses.
Can I please say something?
Okay, I want you to
Hold
speak.
on just
a
1
moment.
second,
Your
Mr.
attorney's going to
Prasad.
speak for you right now. And then if he needs to make a call,
Unfortunately,
we can recall.
there is no, I've spoken with Mr. Prasad, Judge. He's been a resident here in Florida all of his life. He has a friend that he can stay with. He is going to career college at this point in time, studying air conditioning repair. He indicates to me that he has never missed court in the past, and I don't know if the state can verify that or not, but that's what he relayed to me.
Well,
And
that's not
and
true.
your honor,
Well, Your Honor,
I never miss court. Can I say something, please? All these charges in my whole life that I've been dealing with is because I was on drugs. Okay, I've been off drugs for the past 2 months. I've been sober. I've been trying to do better. This stuff that just happened, I didn't aggressively try to beat anybody up.
Don't
I didn't.
discuss the facts of your case, Mr. Prasad.
I know what I'm doing. I didn't intentionally spit on the lady. It was accidental. And miss, if you can please give me a chance, because I want to stay in school and I want to continue doing my landscape. If you can please give me a chance on pretrial and I'll stay sober, you can keep me drug tested. I'll show up to court. But please, can I please have a chance, ma'am, for the holidays? I will do good, and I promise.
Okay,
Your Honor, I can advise the court, because you're not here regularly. I'm familiar with Mr. Prasad. Every time he comes through, he talks about the school, going to school for AC.
Because I'm in school now.
Hold on, Mr. Prasad. We don't interrupt each other during legal proceedings.
I apologize.
He gives the same story every time, but yet.
But you're trying to make me look like such a bad person when really.
Okay,
I
so
was
this
a
is what
drug-
the court's gonna do. For charge number 1, bond will be at the 1,500, and for number 2 at 500. Anthony Bellamy,
He's here, President. Happy holidays, Judge.
same to you, sir. All right,
Your Honor, here is Mr. Bellamy's here in a second look. It's a felony theft, and frankly, it's not for a substantial. The property value isn't substantial. The concern is, and I think the concern that Judge Levy-Cohen had, Mr. Bellamy was out on pretrial last year for felony theft before Judge Fine. And pretrial had to bring a revocation warrant to Judge Fine because he was on a GPS monitor. He failed to charge the monitor. It died, and pretrial was not able to keep track of Mr. Bellamy. At the time of the warrant, his whereabouts were unknown, and Judge Fine said a $10,000 bond. And I think that's a concern because I imagine Mr. Romero is going to be requesting pretrial, but he's shown as recently as last year that he was unable to follow the requirements.
Judge, I know that he had, I believe, an original bond of 750, and I believe it was raised to 1,000. I don't remember it being raised to 10,000.
No, I said,
but I could be wrong.
Hector, I said the bond that Judge Fine set on his warrant for violation of pretrial was 10,000.
Oh, okay, then I misheard. But as you can see right now, Judge, bottom line, he's here on a felony, petty theft. This is a nonviolent offense. We're talking about $9.42. That's the alleged amount that was taken. Judge, right now, he just got a job. He was working at the Gulfstream. There's a carnival there. Unfortunately, the carnival now is packed up and moved, and I believe now they're going to Dade County. From what he advised me, that job opportunity is still available to him. He lives here locally with his sister in Fort Lauderdale, but his sister cannot afford to post that $1,000 bond. Judge, rather than him being here for the next 30 days and wait till the state finally files the case and then he could potentially resolve it for supervision, I'm asking at this time, rather than him being in custody 30 days, let him out under supervision of pretrial on this nonviolent offense, Judge.
And Your Honor, the only two options aren't either you let him go to pretrial or he has to sit for 30 days. The public defender has more than enough time between now and then to go before his assigned judge and put something together that will maybe elicit a little more confidence that Mr. Bellamy will be able to follow pretrial this time around. I can tell you he has a lengthy history as well. Not necessarily high-level offenses, but just repeat arrests, Your Honor. And I'm only bringing this up because there are other options.
okay, so the court's gonna find probable cause, but what we're gonna do here is we're gonna release him on standard pretrial, but I want him to call 3 times a week.
You heard me?
No,
I said I will not let you down. Thank you.
okay, you're welcome. Kelvin Washington,
Judge, I'm actually speaking with him right now.
you're speaking with him, we'll take a brief.
Yeah, we just put him on recall. I think Mr. Scullion, the next case on the docket is bond.
All right. Richard Scullion,
He's out of custody.
for sure? Okay. All right, Mr. Lind, I think the last one is going to be the Kelvin Washington, right?
Yes, whenever Mr. Reedy's ready, I'm ready. What is all this stuff doing? Look at this. Just pass it upstairs, don't throw it out. There's stuff here that shouldn't be.
How's it going?
It's going pretty well, Judge. I think we're done here at Maine.
Yeah, Mr.
So I'm gonna
Reedy's on the phone.
take off.
Yeah, sure.
Are you gonna be here during, this week at all? Any other
No.
days? No?
Yeah,
Always a pleasure, Judge.
you too.
Yeah. I can understand. No. I didn't even say that out loud.
Judge, I'm ready on Mr. Washington.
Okay. Just one moment, Mr. Reedy.
This, no rush at all, Judge.
Okay. All right, Mr. Washington?
Hey, how you doing, ma'am?
Oh, Paul Ryan? Okay. Hello, sir.
Hey.
All right.
This is a second look. Mr. Washington is out on bond $3,500 for second-degree felony dealing in stolen property, $1,000 for using an anti-shoplifting device, and $100 for trespassing in an occupied structure or conveyance. I'm asking that the court keep the bond in place. Mr. Washington, at the time of committing this offense, was out on bond for felony theft. So he's already violated his conditions of bond with this arrest. He's also shown an inability to appear in court. Just less than a month ago, he was arrested on November 8th for a capias on a petty theft. He was arrested in August of last year for a capias on another petty theft. Both of those ended up getting pled out. In 2017, he was arrested for failing to appear in court on one case of a misdemeanor petty theft and another a felony grand theft. He pled both of those out. He's got another theft from 2015, 2 counts of attempted burglary, 2011, burglary of a dwelling, 2008, grand theft auto, 2008, unlawful use of false name ID, 07, carrying concealed firearm, 06.
I certainly appreciate the state's position, Judge, but the fact of the matter is Mr. Washington is not going to be able to post that kind of a monetary bond. He has been a resident of South Florida his entire life. He's been working for Cooper Lawn Service for the last 6 months. And as he was quite candid with me, when I asked him if he had ever been in any trouble before, he didn't try and hide it or anything like that. He was very, very honest with me about it. His total bond, as I counted, is a $4,600 bond, which he is just not going to be able to post. He doesn't appear at this point. He's trying to work with some people outside of the jail, family and friends, to post some bond. But I believe that $4,600 would be above what his expectations would be that his friends or family could come up with. I'd ask the court to consider pretrial release. If the court is not inclined to consider pretrial release, I'd ask the court to consider reducing his bond, maybe to something in the area of a total of $2,500.
Your Honor, Mr. Washington is fortunate. He's fortunate to even have a bond right now, considering he violated his bond on the pending theft-related case, and that his bond wasn't at least increased on these charges, considering the pending case and his prior failures to appear, and thefts had to have been considered aggravating factors.
Okay, the court's going to keep the bonds in place.
Good luck, Kelvin.
All right, thank you.